Now recognize the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Good morning to all of our witnesses. Ms. Barr, you previously testified that the former Secretary's email arrangement with herself was not acceptable. Those are the words you used, not acceptable. What made it not acceptable to you?
I thought that I know that in my oral statement today I was talking about it. Our backlogs were not acceptable, but I think that in my former testimony that was being asked if I thought in general it was okay to use if any employee would use a private email account.
Right. No, you're exactly right. It was in response to a question when you testified before the Senate. And I'm sure the circumstances were, was it okay to exclusively use personal email with which to conduct public business? And you used the phrase not acceptable. So I'm not asking about the backlog. I'm asking about the exclusive use of personal email with which to conduct public business. What makes it not acceptable?
What we want to make sure that we do under the Federal Records Act is to capture official records so that they are available to be history of what we do and how we come to those decisions. We don't like for records to be separated from the agency. So we were very pleased to have these records back in our possession so that they're part of our collection and that we can make them available to the public.
Do you recall why former Secretary Clinton said she availed herself of a personal server and used exclusively personal email? Do you recall the explanation given? Or have you been given an explanation for why she went that route?
I can't speak to that authoritatively. My understanding is that the Secretary said that she did it as a matter of convenience.
And you know what?
I don't know that personally. Sir.
Well, that's my understanding too, in part because that's what she said. I guess my next question would be, if it was solely for convenience, why not return the records the day you separated from the State Department?
I have no information on that, sir.
Has she provided any explanation for why she retained care, custody, and control of those public records for almost 2 years after she separated?
I'm not aware of that, sir.
Do you know what prompted
now?
Do you know what prompted the former secretary to return those public records to the public domain?
We sent a letter to Secretary Clinton as well as to Secretaries Rice, Powell, and Albright, and asked them if they had any records that they might have been generated on non-department systems that should be part of our official records.
How were you able to comply with FOIA requests in that almost 2-year interim between the time you wrote the letter and the time that she retained care, custody, and control of all of those public records?
Sir, emails are not the only records.
Right, but it's part of the record. So if you received a FOIA request that would have included emails, how would you have been able to comply with that FOIA request, given the fact that you had neither care, custody, nor control of those records?
Well, we would still search all of our records, and we would still look at things like cables, decision memos, other types of documents that we keep to provide a record of what we do, agendas.
So you would have given what you had, but you would have made no representation that what you provided was complete, because necessarily it could not have been complete because you didn't have the full panoply of public records.
Well, we always look at what we have, sir.
Right. You can't give it if you don't have it, which then raises the next question I have. I was listening to my friend from Maryland and my friend from Virginia make note of the fact that the former secretary did return emails. What guarantee can you give my fellow citizens that what you have now is the complete public record? Have you been through all of her records to determine what's public and what's private?
We are processing them now, and no, we have not completed our review.
You're processing what was originally on the server, or are you processing what she provided to you?
We are processing what she provided to us.
Do you know what mechanism she would have gone through to determine herself what was public record and what was private, or what may have been a mixed use? Do you know who made that initial determination for the former secretary?
She has told us that she erred on the side of inclusion.
Did she tell you that she personally reviewed all of the emails, or did she retain counsel to do so?
I'm not aware of whether she personally did it or if she retained counsel.
Well, I thank you for answering my questions. I am over time. Suffice it to say, I have a number of additional questions in this area, and perhaps at some point I'll be able to ask them to you.
Gentlemen,
But
you just for a moment.
I'm out of time, but if the chairman says I'm not, then I'm not.
Just one question. Ms. Barr, what emails are you processing for Secretary Powell, Secretary, and Secretary Rice? You said you're processing emails.
Oh, for Clinton.
Yeah, I mean, yeah, but what emails are you processing for Secretary Powell? And listen to me, Secretary Powell, any?
No.
Are you processing for any for Secretary Rice?
No.
All right, thank you. I yield back.
I'll recognize the gentleman from North Carolina for 5 minutes.
Thank you, Mr. Chairman. I would like to yield my time to the gentleman from South Carolina.
I thank my friend from North Carolina. Ms. Barr, I appreciate you talking with me earlier. I want to pick back up where we were. I was seeking some level of assurance from you, to the extent that you could give one, that what was produced to the State Department did in fact represent the full universe of what would be public records. And again, I have no interest in private documents. I really could care less. I am interested in making sure the whole public universe is complete. So what assurance can you give the public that that State Department has everything that would be considered a public record from her tenure as Secretary of State?
She has assured us that she gave us everything she had, and like we do with other federal employees, we have to depend on them to provide that information to us. So we have the documents, and you know, we've accepted her assurance that she's given us everything that she had that should be a part of our official records.
Well, you mentioned other federal employees, which got me wondering, and I wrote down a list of some of the other cabinet level folks that I have worked with in my time here. Attorney General Holder, did he have his own server?
Are you asking me?
I'm asking whoever can answer it.
Well, I could let you know that Attorney General Holder used an official DOJ account.
He did. How about new Attorney General Lynch? Does she have a personal server?
Same as well. She's using an official DOJ account.
What about President Obama? Is there any indication? Because if you're going to pursue the theory of convenience, I can't really imagine a busier person on the globe than President Obama. Did he have his own personal server? Ms. Barr?
I have no knowledge.
Well, the reason I'm asking is because you said that you're doing it the exact same way you would with any other public official, and my point is because of this arrangement that the former secretary had with herself, you're not in a position to do it the same as you would with any other public official, because Vice President Biden and President Obama don't have their personal attorneys going through their emails to decide what to return and what not to return. I assume in your position is an apolitical, non-political, unbiased position. Am I correct in that assumption?
Yes, sir.
And I believe the Department of State has an Inspector General. Am I right?
Yes, and we've asked the Inspector General to look into some of these issues. We are cooperating with them.
I know you have, and I didn't mean to suggest otherwise. Do you know who nominated the current Inspector General?
I don't have that information at my fingertips, but I can get back to you.
You don't have to, because it was President Obama. Do you know who controlled the Senate when he was confirmed? Do you know what the vote was? It was unanimous.
No, I knew you were going to give me that information.
It was unanimous. Those may be the only questions I can answer today, but I do know the answer to those two. President Obama nominated the current Inspector General, and he was unanimously confirmed by a Senate controlled at the time by Democrats, which makes me think that he, like you, is a neutral, detached arbiter who is solely interested in separating what should be in the public domain from what should be purely personal. So why not let the Inspector General look at all the records just to make absolutely sure, and that way we're not in a position of having to take someone's lawyer's word for it. Why not do that?
Well, it was my understanding that, you're talking about the email collection, not the entire process?
No, I'm talking about, I mean, you have been put in the position of having to take a lawyer's word that you have all the public records. And perhaps it's just the cynicism of actually being a lawyer. I'm just wondering who with a fiduciary duty to the public can make sure that the public record is complete. Instead of the former secretary hiring an attorney to do it, why can't the attorney that works for all of us? Why can't the Inspector General do it?
So you're asking me, why can't the Inspector General make the determination of whether we received all of the emails?
Yes.
I really can't speculate on that.
Well, I'm out of time. Hopefully I'll get some more time, and we can speculate together after that. I yield back to the chairman. Brett, did you hear the president say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the president say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the president says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about? Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the president say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the president how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that? I understand why she invoked her Fifth Amendment privilege. I don't understand why in the hell the President of the United States would prejudge an investigation
I don't either.
before any of your clients were interviewed, before either of these 2 victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these 2 victims were interviewed. He has gone on national television. He has prejudged the investigation, and in my judgment has compromised the Department. Chair now recognizes himself for questions. Mr. Rubin, have you read the House resolution?
Pardon me. Yes, sir, I have.
What is your understanding of what this committee has been asked to do?
My understanding is that the committee has been asked to review the incidents related to the Benghazi attacks and all of the, as you described at the beginning, in all of the aspects that it seeks.
So your understanding is that we have been asked to look at all policies, decisions, and activities that contributed to the attacks?
Certainly, that's our understanding, and we support providing the information related to that request.
That affected our ability to prepare for the attacks?
But if that's ultimately the decision.
Well, you've read
about the
it, right? I mean, you've
specifics-
read the resolution, right? You're not disagreeing with my
No, I'm
interpretation
not,
of the resolution,
and
are you?
we defer to the committee's direction on how it wants to proceed.
Including executive branch efforts to identify and bring to justice the perpetrators of these attacks? Did you read that in the resolution?
Sir, I don't have it in front, so I can't quote it
I'll be
verbatim.
thrilled to get you a copy of the resolution. For the meantime, you're just going to have to take my word that it also says executive branch efforts to identify and bring to justice the perpetrators of these attacks. That's in the resolution. Can you tell me specifically how our interviewing witnesses is going to jeopardize the prosecution?
Sir, the Department of Justice has been clear with us.
I'm asking you. It was in your opening statement. I'm asking you. You tell me, a former prosecutor, how our interviewing witnesses that have already been interviewed by the ARB, already been interviewed by the Best Practices Panel, and frankly, already been interviewed by the State Department. The video that you showed us last week, that agent interviewed the witnesses in preparation for a video. So if the ARB and the Best Practices Panel and your own agency can interview people in preparation of a training video, how can Congress not interview those witnesses?
Sir, no one has said that Congress cannot interview.
You just said that it would jeopardize an ongoing prosecution, and I just asked you specifically how.
My understanding, and I am the chief liaison to the House for the State Department, is that our colleagues at the Department of Justice have been in touch.
Specifically,
with your
who told
staff.
you that?
My colleagues within the State Department who work on this on a daily basis.
I'm looking for a name because I've got to clear up this misconception that simply talking to a witness who's already talked to 3 other investigatory bodies, that somehow or another Congress cannot talk to these witnesses, even though apparently everybody else can. I'm curious how that jeopardizes an ongoing prosecution.
Sir, I'm not an attorney. I'm not a prosecutor. What I am is the chief liaison to the House for the State Department. And what I am conveying is that the Justice Department has told us that this could have an impact, and they would like to have a conversation with you and your committee about that.
Do you believe that Congress has the constitutional authority to provide oversight?
Every day I do that with my job, yes, sir.
So you do agree with that. What is your interpretation of the phrase all policies, decisions, and activities?
In what context?
In any context. How about contributed to the attacks? What is your understanding of all policies, all decisions, all activities?
The approach that we are taking at the State Department is to provide materials to the committee at the direction of the committee. The request for interviews that you have reiterated here today, I am explaining that the Justice Department has said that they would like to have conversations with the committee for the concern about the protection
Mr. Rubin,
of the welfare of these agents.
I want to ask you something. I want to ask you something, okay? Because there are 12 people up here who may not agree on another single solitary thing, but every one of us agrees that we don't want to do anything to jeopardize the physical security of anybody who works for this government, nor does anybody on this dais want to do anything to jeopardize an ongoing prosecution. Okay, can we stipulate that nobody wants to do either of those things?
Certainly.
Will you also stipulate that you can talk to witnesses while preserving their identity and not jeopardizing an ongoing prosecution?
I am confident that in the conversations between the Justice Department and the committee that those modalities can be discussed. I am not the expert on
Mr.
how
Rubin,
those modalities
do you see the Justice Department at this hearing?
No, sir.
Do you know why they're not at this hearing?
No, sir.
Because we don't have any issues with them. That's why they're not here. You just cited a reason to deny access to witnesses that even the Justice Department hasn't cited. So what I want you to do is help this committee gain access to precisely the same witnesses that everyone else, from the ARB to the Best Practices Panel to your own agent who compiled a training video, had access to the witnesses.
Sir, as I said in my opening statement, we are happy to have the conversation with you and your staff on how to engage on this. And that is something that we're open to. We have never said no.
Well, I appreciate that. I appreciate that. But I want to make sure that you and I have a clear understanding with each other. If 6 people observed an important event and you were being asked to write a final definitive accounting of that event, how many of the 6 would you want to talk to?
Sir, I understand.
That's not a trick question.
I know it's not a trick question, and I understand the point, and this is why we are here.
Well, if you
This
understand
is
the
why we
point,
provided the quantity of documents and worked in collegial terms.
Mr. Rubin,
with
we're going to
you and
get we're going to get to the quantity of documents in a minute. I noticed that you said 40,000. That's an impressive number. That's 40 copies of Dr. Zhivago. That's 40 copies of Crime and Punishment. That's a lot of pages. 40,000 out of how many? That's our question. How many documents? Is 40,000 half? Is it all? Is it 2/3?
We have made a comprehensive search, and as you know, the State Department spans 275 missions overseas, 70,000.
I do. I'm not asking you to bring any ambassadors
we have provided
back.
a comprehensive amount of.
I'm not asking you to bring any ambassadors back to search for emails. I'm not. Not a single one. How many employees does the State Department have?
Roughly 70,000.
70,000?
Correct.
Right. And we have asked for emails from seventh floor principals. Do you think that that is a reasonable request when you have been asked to study all policies, all activities, and all decisions?
In your committee's December letter, where it named principals, first, in fact, all of those principals there are emails, there are documents related to them in that 40,000. And in addition, you and your
Is it your testimony
colleagues,
that we have all of the emails that we've asked for?
well, you and your colleagues prioritize former Secretary Clinton's emails, and that is our priority, as I stated in my opening
Well, I would say multiple emails. If there are multiple email accounts, we want all of the emails.
And
okay?
we agree, and we are, as I
Well,
stated
you may have
earlier,
noticed
we
my
provide you
colleague
with-
from Maryland used the word glacial. I find the use of that word interesting when you vote against constituting a committee, when you threaten not to participate in the committee, when you continually threaten to walk away from the committee, when you can't identify a single solitary person that you would issue a subpoena to, when you are prepared to have an ask and answered website before you got the 15,000 pages of documents that you just provided, when you expect members of Congress who are having conversations with people on airplanes to stop the conversation and say, let me go get a Democrat. You heard the word glacial. We're going to pick up the pace. We're going to pick up the pace. I have no interest in prolonging this. None.
Sir,
So
I
you're going to
assure
have
you
to
that-
pick up the
that
pace
we do
with us,
not.
okay?
Absolutely, and this is why we're here today. We have made 2 witnesses available since the fall of last year. We are prepared at any time, proactively, as you and your colleagues know.
I appreciate that, Mr. Rubin. Are you familiar with the subpoena that dates back to 2013 that the Oversight Committee sent with respect to the ARB?
Yes.
Okay. ARB is a statutory creation, you agree? Congress created the ARB?
Yes, it did.
Do you agree Congress can amend or alter or enhance the ARB? If it's a
through an act
statute,
of
sure.
Congress.
Can change it, right? You agree Congress should provide oversight over one of its statutory creations.
Yes, sir.
How can we do that if you will not give us the documents related to the ARB? How can we possibly do that, Mr. Rubin?
Sir, first, of the 40,000 pages of documents that the committee has received, many of those are, in fact, related to the ARB.
Mr. Rubin, I appreciate, I really do. I really do. I appreciate the word many. I appreciate the 40,000. I keep coming back to one word that's in the House resolution, and that word is all.
So, sir,
do we have all of the
we,
documents?
What we have communicated to you and to your staff, and what we've been grateful for, is the committee's explanation of its top priorities. And we would be very honored to continue to have those discussions if the ARB, as you've noted here, becomes the top priority.
Well,
that is certainly,
Mr. Rubin, we shouldn't have to pick among priorities. You have 70,000 employees. I mean, what we're not going to do is identify one tranche of emails and then 2 months later go depose or do a witness interview with that witness, and then 2 months later get another tranche of emails. When our colleagues on the other side, who, by the way, had no interest in forming this committee whatsoever, but are now ironically complaining about the pace of a committee that they had no interest in forming whatsoever, it's time for us to pick up the pace. And I'm looking to you to help me do that.
And that's why we're here, and that's why we have continually engaged proactively with you and your committee, and we're happy to continue to do so.
Okay.
And I would mention the 70,000 employees are engaged in their jobs.
I appreciate that. I don't want any ambassadors, security guards. I don't want any anybody taken off of an important job. But compliance with congressional inquiries is important, and if you have time for condom demonstrations or culinary diplomacy, I think you have time to comply with a legitimate request for documents from Congress, and I'm sure you agree. And with that, I would recognize the gentleman from Maryland. Thank you, Mr. Chairman. Mr. Schulman, when you learned that conservative groups were being targeted by the IRS for discriminatory treatment, what did you do?
When I learned of the existence of a BOLO list, in that same conversation or right around that time, I also learned a couple things. One, that it was being stopped. So that.
All right, and who told you it was being stopped?
That's Steve Miller, my deputy.
All right, and did you investigate further? Can you give me the name of a single person who was involved in the original decision to target conservative groups for disparate treatment?
I'm not aware of those names.
Why can't you give me a name?
So at the same time that I learned and that it was being stopped, I was also told that the Inspector General was aware of it.
Mr. Schulman, is the Inspector General the only person who can investigate wrongdoing within the IRS?
My general practice.
Can you answer my question, and then you can explain? Is the Inspector General the only entity who can investigate wrongdoing?
Congress can investigate.
How about you? Can you do it?
The practice at the Internal Revenue Service that I inherited.
So if there's inappropriate conduct being done on your watch in the IRS, then that inappropriate conduct can last as long as the Inspector General's investigation lasts. Is that what you're telling me? That you're not going to step in and stop it?
No, what I'm telling you.
If there's someone wielding a knife in the parking lot, are you going to call the Inspector General? Are you going to wait until his or her investigation's over before you stop it?
When I was told about these allegations, I was also told that they were being stopped, and so that the inappropriate criteria were not being used
anymore. And despite the seriousness and potential criminality of that conduct, you didn't investigate it yourself at all?
So the procedures that I inherited and that my
Mr.
general
Schulman,
practice
this is going to go much quicker if you'll answer yes or no, and then you can explain. Did you do anything to verify that the practice, as insidious as it was stopped?
The Inspector General was going to be looking into it, and that's what.
Is it that you can't say yes or no, or you're just choosing not to say yes or no? Can you answer the question, did you do anything personally to make sure that this insidious, discriminatory practice was stopped? Yes or no?
At the time that I learned about it, I also learned two things. The first was that it was being stopped, and the second was that the Inspector
And what did you do to verify that it was stopped?
The responsible deputy of the Internal Revenue Service told me it was being stopped. I had no reason to believe otherwise.
Did you investigate why conservative groups were being targeted?
Excuse me?
Did you investigate? So you can't give me a single name. You can't answer the who. Can you tell me the why? Why were conservative groups? Why was the culture such under your watch that an employee felt comfortable targeting conservative groups? Did you investigate that?
You know, from my reading of the report, I can't tell if it was political motivation or if it was tone deaf, somebody trying to expedite a way.
You still don't know that this was political.
Excuse me?
You still don't know that this was political?
I defer to the Inspector General.
Well, I'll tell you this, Mr. Schulman. Your predecessor said that he wasn't sure if it was partisan, and that requires the listener to be as stupid as the speaker to utter a comment like that. He just testified that policy positions dictated this. What does that mean to you? If it's not partisan, what does that mean?
I'm not sure I heard that testimony.
Well, we'll be sure and get you a copy of the transcript, and you can supplement your testimony. How's that? Do you agree with Dan Pfeiffer?
Committee's questions.
Do you agree with Dan Pfeiffer that the law is irrelevant, or do you think it is relevant?
I think the law is always relevant.
Do you think 26 U.S.C. 7214, which provides for criminal penalties for this conduct, would be relevant? And did you refer the matter to someone with law enforcement investigative jurisdiction?
I'm not going to speculate what's appropriate legally in this matter, and Mr. George, I knew his operation was looking at it, I believe.
I thought it was an audit. I thought he just testified it was an audit, not an investigation. Did you refer it for criminal investigation?
I didn't refer it. It was already being looked into at the time that it was brought to my attention.
So I want to be real clear because my time is out. The only recourse you have when there's an allegation of wrongful conduct on your watch, the only thing you feel comfortable doing is waiting on an inspector general to finish his or her report.
The general practice is to make sure the inspector general will look into it.
No matter how insidious the conduct. If it were an allegation of racial discrimination, you would have waited until Mr. George finished his investigation? Is that your testimony?
I'm really not going to answer hypotheticals.
I tell you what, instead of answering a hypothetical, why don't you answer the case at bar today? If there's an allegation that groups are being discriminated against based on political ideology, are you really going to wait until an inspector general finishes his or her report before you take corrective remedial action?
When I have a fact, but I don't have all the facts, and I don't know the scope and severity.
Did you investigate the facts, Mr. Schulman? Did you lift a finger to identify the facts?
Felt very comfortable. The facts, the inspector general was going to run down the facts, and once he had it, it would be reported out.
Let the record reflect that's a no.
I thank the gentleman. I know you guys have been there a long time. We appreciate your patience.
Thank you, Mr. Chairman. Commissioner, you're an attorney. Can you explain for our fellow citizens what the phrase spoliation of evidence means?
I have no idea what that means.
Well, I'm going to help you with it, okay? Spoliation of evidence is when a party fails to preserve, there's a negative inference that the jury can draw from their failure to preserve the evidence. You with me? If you destroy documents, the jury can infer that those documents weren't going to be good for you. If you fail to keep documents, the jury can infer that those documents were not going to be good for you. You've heard the phrase spoliation of evidence, haven't you?
I can't recall ever hearing it.
It's true in administrative hearings, civil hearings, criminal hearings.
I practiced law once 45 years ago, gave it up for Lent one year, never went back.
All right. Well, let me tell you what you would have found if you had stuck with it. When a party has a duty to preserve evidence or records and they fail to do so, there is a negative inference that is drawn from their failure to preserve the evidence. It's common sense, right? If you destroyed something, the jury has a right to infer that whatever you destroyed would not have been good for you, or else every litigant would destroy whatever evidence was detrimental to them. Agreed?
I'm not sure. I think if you destroy the evidence and people could prove it, it wouldn't be a good thing for your defense.
Well, no, it's worse than that. The jury can draw, and they're instructed, they can draw a negative inference.
All right.
And that's true if a taxpayer is being sued by the IRS administratively, civilly, or prosecuted criminally, and they fail to keep documents, the jury can draw a negative inference from the fact that they didn't keep receipts or emails or documents. So if it's true and applies to a taxpayer, it ought to apply to the IRS as well. Agreed?
Is this a trial? Is this a jury? Is that what you're...
I said administrative, civil, or criminal. If you want to go down that road, I'm happy to go down it with you, Commissioner. In fact, I'm glad you mentioned it. You have already said multiple times today that there was no evidence that you found of any criminal wrongdoing. I want you to tell me what criminal statutes you've evaluated.
I have not looked at any.
Well, then how can you possibly tell our fellow citizens that there's no criminal wrongdoing if you don't even know to look at?
Because I've seen no evidence that anyone consciously...
Well, how would you know what elements of the crime existed? You don't even know what statutes are at play. I'm going to ask you again. What statutes have you evaluated?
I think you can rely on common sense that nothing I have seen...
Common sense. Instead of the criminal code, you want to rely on common sense. No, Mr. You can shake your head all you want to, Commissioner. You have said today that there's no evidence of criminal wrongdoing. And I'm asking you what criminal statutes you have reviewed to reach that conclusion.
I've reviewed no criminal statute.
All right, so you don't have any idea whether there's any criminal conduct or not because you don't know the elements of the offense.
I've seen no evidence of wrongdoing.
Oh, well, that's very different than no evidence of criminal misconduct, Commissioner.
Well, it seems to me if you haven't done wrongdoing, it'd be pretty hard to argue that you've had some criminal violation if you did.
Well, what
something
did
wrong.
Lois Lerner mean when she said perhaps the FEC will save the day?
I have no idea
What did she say? What did she mean when she said we need a project, but we need to be careful that it doesn't appear to be per se political? You don't think that's a potential violation of 18242?
I have no idea if it.
Because you haven't looked at 18242, and you don't have any idea, Commissioner. You don't have any idea whether there's any criminal wrongdoing or not.
With regard to the production of the evidence, the production of Lois Lerner emails, I have seen no evidence of wrongdoing. What else?
Well,
went on, what
if
else
there
went
were,
on,
that would be a separate criminal offense.
What else went on with Lois Lerner? I said in the past.
So what
there
you're
are
saying is
6
you don't have any idea whether
investigations
she engaged in criminal wrongdoing. You're just saying that you did not engage in any with respect to the email.
I haven't seen any wrongdoing with regard to the production of Lois Lerner emails.
But you are not saying there was no criminal wrongdoing with respect to the targeting of conservative groups. I want to be very clear. You're not saying that.
I've made no judgments.
So you disagree with the president when he says there's not a smidgen of corruption.
There are people who have been making judgments both sides about whether there.
You know what? I'm not one of those. I'm just simply saying we will never know because you didn't keep the evidence. The evidence was spoliated. And whether it's negligent, whether it's intentional, whether it's reckless, we still don't have the evidence, Commissioner.
Well, you have the evidence that there is no emails from the White House. You have all of the Treasury emails. So the basic premise that this was an argument in a conspiracy driven by the White House does not.
No, sir, you're wrong about that. You're wrong about that. That you're repeating a talking point from our colleagues on the other side that we're obsessed with the White House. It was Jay Carney who perpetuated the myth that it was 2 rogue agents in Ohio. It wasn't any of us. Was that accurate? Was that first initial line of defense that this is just 2 rogue agents in Ohio? Was that accurate, Commissioner?
Not that I know of.
All right, so that wasn't accurate, and that came from the White House. Who said there's not a smidgen of corruption? Who said that, Commissioner?
My understanding is that was the president.
All right, it was the president. So that's Jay Carney and the president both inserting themselves into the IRS scandal. And you want to blame us for bringing the White House into it?
I haven't blamed you at all.
You just did, Commissioner. You just did.
Well, it's a good argument. All I said was the White House has revealed there were no Lois Lerner emails. Treasury has given you all of their emails. So to the extent that the argument was that Lois Lerner was conspiring and emailing back and forth, thus far I haven't seen any.
But you can be engaged in a conspiracy that doesn't include the White House.
Gentlemen.